Geo.
You, mischief has been created. Your initial Geo is 2011. Like that, if we have understood, no, Mr. Chandran, if we have understood correctly, your case is that in 2011, though you were ranked below, but the government came out with a policy that not be a cadre anymore.
Abolished that.
Abolished. Everybody merged. So at that point of time, whoever was in the senior was senior to you, and you became a problem. But after that, you had to be considered as a full-time DT, PG.
No, I
Just a minute. So whoever comes later, even by merit, has to come below you.
Yes.
As simple as that is your case.
It is, but if I may clarify one small thing, small additional fact.
Yes.
So when I get merged in 2011, I'm born into the cadre in 2011.
Exactly, at the lower rung.
But the respondents here
They came in 2013.
as supernumerary. They were ad hoc appointments additionally created in 2013. They come in, so they're not even born into the cadre till today.
Let us issue this. Let us state.
Yes, yes. We'll have to answer.
This order of 13/5/2011 was set aside by the Highcourt, accepted by them. That has become final.
No. They always challenge that. Never accepted this. That is what they have a very good arguable case.
Respondents accept non-applicable.
Otherwise, Lord, I am with my learned friends, the matter can be heard.
Who's for the state of UP? Is accepted.
There is already an order of, if you want to kindly see the application, it is mentioned in the application, so it's a matter of interest minorities. And the fact which my learned friend mentioned that we were born in 2013 is actually incorrect.
You're not hearing arguments today. Would you like to file a reply?
We'll file. We'll file.
Please file a reply. And we'll see after hearing your application, you may take up the matter itself.
Right.
You will learn it comes from both sides, mentally be prepared for that also.
Yes, great.
Besides the application.
Yes. Sorry. Great.
Item 2.
Yes.
Before I'm starting, there is some delay, and I'm sorry, Lakshmi, that's not properly explained also.
Yes,
They
it's
said,
3 days delay is it in this.
let me file a fresh, better.
Not on merits also.
Which the issue is here, is the standard of proof required in the civil suit and the presumption 118 is totally different. Mechanically applied the presumption of 118 and the entire proceedings are on that basis. So this is perverse. The standard of proof required in the civil suit, there is no pleading at all. Let me kindly see page number 4 election.
Let us see page 4.
You got partial relief from the High Court.
Yes, it was.
Not sure the entire money and deposit. That's another issue. And deposit their money. The question of blood is decided, Lordship.
No, your liability, we don't see that you free of liability.
No, just I'm pressing the question of law, Lordship.
What
the
law?
thing
Kanai Act would be the different proceedings.
That is
No
what
comparison with the civil suit.
this is what is the mention.
The decree was passed after modifying it. The court gave you benefit, 3,25,000 with interest. We see no reason to.
You got a relief for 1.25.
There are no explanation for the on merits, and even on delay, even on merits, we do not find a fit case for interference. Discuss it next.
Lordship, the question of law we can fit from here.
No question.
What for you? How are you bothered question law?
No question here. Next.
Please, sir.
In this particular case, my lord, I am really pressing my compensation should be increased, my lord. The Labour Court has awarded 50,000 as compensation. High Court has modified it to 2
lakhs.
2 plus 50.
Plus
For 2 years, from 50,000, 2 lakhs.
96 you are appointed.
Mother, 2000.
86 July 86 to November 88. Why would this not be sufficient? That also 86 88.
And you came after 26 years. First time you agitated this matter. After 26
So much
years.
of time.
And still you've been given 2 lakhs.
The
Please
don't the
satisfy.
delays, 2 minutes. Don't vote the delays.
Item 4.
Thank you, Your Lordship. I am limiting my arguments only on the quantum sentence, Your Lordship. I have been acquitted in the criminal proceedings, Your Lordship. And
Sentence. What about sentence? There is a
You
question.
slap your superior and you this quantum. You want indulgence from this court.
Your Lordship,
You have the power to have
Your Lordship, I've been.
Luckily for you.
in the departmental, you have been found that yes, evidence came, an independent lady came and said yes, you had slapped the senior. Enough for that. Go out,
Sorry, we are not.
out of the door.
Yes, sorry, not this kind of a conduct from an employee. Dismissed, condone the delays. 2 sets of delays.
Item 5.
Yes, please.
Let's may consider this fact, madams. On 4th July 2018, there is an application made by the employee. Within a period of 1 month, around 1 month, madams, the payment was made. Now the rules, madams, the All India Executive Rules for Payment says that there should be an application made by the employee. And as soon as
What? Leave encashment amount. Documents you will not give.
there should be an application, there is a performa
The
act.
process, you will retain it.
No.
Isn't it the right of an employee to leave encashment amount?
Yes, it is right.
Then why is that he has to make an application?
Madam, because the rules and performa say so, that there should be an application. He's entitled to it. I'm not denying his time.
And assuming he retired in service in 17 and it doesn't apply, he will keep the money and not pay interest to you.
Counsel, you are conveniently forgetting there is a departmental circular that the 1 month prior to the or 3 months prior to the retirement, the officer is supposed to call him, get everything filled up. He doesn't know about it.
Well, it's because it's general
And I know, and that is also statutory which has been given. The statute casts an obligation of 9% for delay. And delay is your part because you did not inform him that these were the procedure requirements. It was your onus.
There is that rule. Come, let's see that, not the one in which he is to apply. The one which mandates an employer 30 days before the retirement of an employee to do all the calculations.
There is a circular probably of yours.
Let's see that. What's that? When the owner passes on to the employee.
What is the obligation of the superior authority, controlling authority, when a person is to superannuate, for completing all the formalities with regard to giving him pensionary benefit? Because the rule is that on the day he retires, he should be given a check of an amount.
No, may I say it, madam? There was a charge sheet which was issued against him. And
Up to that point, you are trying to take us on. So you may be justified that the rule says that till the time it is not finalized, you can withhold that. That is one thing. But now if in your departmental itself you have exonerated him, then he should get
When
pensionary.
you exonerated him in June 2018,
Please.
all the charges,
Please.
when was the money released?
On 4th July 2018, application is made, and on 17th 8 2018, madam, within a period of 1 month.
What, 1 minute, 26,
Here 4 months. How much is that? 1 lakh, 1.2 lakh?
you've been
How much?
imposed costs also by the court.
Well, may I say it, the reason why I am here, the reason patient would be.
You have
This is
a
the
cushion.
this is
You
the
give
basic.
dividends of multi-hundred crores to everybody, and for your employees, you will be stingy. Don't take that high moral ground, counsel.
That return of the employee. Discharge your owners 30 days before the date of retirement of an employee. Calculate it, don't expect him to go giving letters to you.
You want to show yourself as a blue chip, this much of dividend give to government, and your employees are will be stingy. Don't take that high moral ground.
No merits.
The question of loan, maybe.
No question of law here. Next.
Item 6.
Grateful.
Please, my lord, with permission, my lord, I seek permission to withdraw the assembly, my lord.
For the petitioner, execution
My lords, they are resolving it, execution is
After the petitioner seeks unqualified leave to withdraw the present petition, leave as prayed for is granted. Petition is dismissed as withdrawn.
highly obliged.
Item 7.
Yes,
Yes, madam. Another set of that notice is issued by.
how do you explain it?
Delay by
227 days in filing,
Yes, my lord.
108 days in
20.
filing.
My lord, we can, he is waiting for that, he will execute, my lord, nothing is happening at the place.
So you will delay, you move the High Court, but you will delay.
No, my lord, High Court, no, my lord,
This is NCDRC.
NCDRC.
Why did you wait for 200?
No. Sorry, he moving the Supreme Court, I meant that.
Yes.
You should have that hangover of
No, but you need to explain that. What did you do to that?
Yes,
And Mr. Counsel, if you say that you are waiting, that means you had accepted it initially. Then why?
No, my lord, he is not.
You said you were waiting for them to execute.
Nothing is happening, my lord.
Nothing is happening is not a ground to explain 227 days delay, Council.
Yes, my lord, that is there, my lord, because
And
that
you
is.
said, you have said actually nothing even to condone the delay. What is your explanation for the delay?
Explanation is that we are given the control of that land, my lord. So that is the.
Or the beyond our control, we don't want to exercise.
That is, my lord, with that, my lord,
Let
the
me
for the
explain
consumer is
to
there, my
discuss
lord.
it on that. Sorry. You
Yeah,
have it on merits.
2227
My lord,
is a
issue notice one also on that, my lord, with regards to it. I will say that he is from the.
You're not addressing us on merits, so we issue notice on both.
The other side.
On merits, we haven't
Sorry,
not yet come.
reply will come if you would have given us a plausible explanation for the delay. Simply saying that, oh, we are waiting for something is
Then we can say that.
beyond your control, tell us what was not in your control.
Then we can say that, well, we will find a better affidavit.
Counsel for the petitioner's appellant states, maybe, states that he may be permitted to file a better affidavit in support of the, for explaining in support of IA number 40491 of 20.
Yes, my lord.
But, wherein, condonation of delay of 227 days has been sought, by him, rather by them. We say that the affidavit will be filed
Within 2 weeks, my lord.
all right, we thought 227 days. No, all right, within 2 weeks,
2 weeks.
please stop.
With
Also, beg to appear for the petitioner item 8. Because we were.
No extension of.
We beg to give them possession on 21st of February.
Application is infructuous, if you've done whatever, that's internal.
That's it, sir.
Take it.
My lady,
So my lady says.
my lady, with permission, just a few seconds, I'm so sorry. Ladies, I just wanted to point out how gross and abuse of process of law. 200 days. I agree.
But my.
Just one point, that they filed an undertaking before the High Court, take 5 months, end of 5 months, file
We are aware of it, you can see their conduct.
7.5 months.
Lie.
My lady says.
And my lady, my lady,
Who will do that?
Don't press.
Please don't involve us. We are not going to extend.
identical matter passed by the court, by this court, 5 lakh rupees passed by the
Does
court.
not wish to press the application is dismissed.
Consequences will follow you. Do whatever you have to
Whatever
do.
you have to.
Don't involve us.
Because there was an artificial classification made based on Bustani and non-Bustani.
And then later on it was decided on.
No, but
Yes.
still they're not,
No, they are not implemented.
courts.
Specific order, more than a year has passed.
So respondent disbursement, next.
Because at least one, maybe because it
No,
is more than.
that's it,
as-
then we'll take.
Yes, may give a returnability, I'll pray for
No, after service is complete. Next,
the statement.
that's the in addition.
Great, keep you.
But actually, the observation got at page 26, period page 48, but there was a delay, the honorable court has acknowledged there is a delay of more than 2 years, but one, and the direction, in para 26, the honorable court is directed to issue fresh statement of account and pay delay compensation, but thereafter, it says ki, if I fail to pay within 30 days, then only the builder will be liable to charge interest. But I am only agreed by the clause 3 where they say that opposite parties liberty to charge maintenance from the date of offer of possession. So ideally should be from the date of issue of fresh statement of account, because if you read clause 3 with
That you can
clause
go
4,
back for a review. Why should we interfere?
not then make any liberty to file.
For the appellant seeks leave to withdraw the present while reserving the right of his client to seek review of the of para 26(3). Clause 3, para 26 bracket 3 of the impugn judgment. He was paid for his granted facility is disposed of as not pressed along with the pending application.
Much obliged.
Thank you.
Lordships, unfortunately, I did not find the previous High Court order. If I may just be permitted to hand over the order, Your Lordships.
Why would you hand it over and not file it?
Your Lordships, by mistake, the other order got filed.
I know. Current counsel for the petitioner states that he may be permitted to file a copy of the order dated
31st of October 2019.
21st of October 2019,
19.
passed by the High Court. Dismissing FAO number 1398 of 18 as withdrawn at the instance of the respondent husband, right? We looked high and low, so we are telling you to do this. so that we same we file within 1 week, list thereafter. Give a date.
You get a date, you get a
7th March, 7th March.
7th March,
11th March.
maybe within 1912, I come to the very limited extent, let the religious, and that too in exceptional circumstances. There is no dispute that the society is running into financial crunch. You also mechanically page 1.2.
So the current finding by two courts, please keep that in mind.
For the same set of employees, for the similar really from the court has considering my financial crunch, areas have been paid. 112 million.
112.
Yes, ma'am. And except period.
Yes. Yes.
Second paragraph. The Land Council for the Appellant has argued that though the direction issued by the court insofar as payment of the benefit arising from fixation of the promotion pay scale is concerned, the same has been granted and released in favor of the respondent, but the challenge if the appeal is restricted only to the extent of 6% interest rate. The Land Council for the Appellant has placed the reliance upon a division judgment to court wherein the interest of the exempted by this court having regard to the financial crunch faced by the appellant organization. The same ground is reiterated in the appeal. The benefit of promotional pay scale has already been granted. The appellant undertakes to make the payment without any delay. In this circumstance, the payment of interest of the amount due shall be exempted. The payment made subject to the final outcome. Similarly, for the same set of employee here, you will also that the court has coordinated basis and
the quantum of interest that would come through.
Quantum for this particular employee, it is not high, around 1 lakh rupees. But this will affect Milord 6 employees. The entire amount will come approximately 49 crores. That is the only issue for all employees. That is the difficulty, and we are making payment and taking loan.
Current Council for states that through the quantum of interest directed to be paid to the respondent on the delayed payment of the arrears of promotional pay scale is not so. Is small, but the ripple effect of this order would impact the petitioner, which is already in the red. Are you in the red? Are you financially and facing?
Yes, I'm financially. I'm paying.
Petitioner, which is already facing a financial crunch, in as much as the ramification of this order will result in a burden of ₹60.
So that is 48.69 crores. So 650
crores. In respect of 660 employees who are similarly placed as the respondent. Subordinate Council particularly seeks to rely on an order dated 10/10/2020 passed by a coordinate bench of the High Court in special appeal defective number 778 of 2023, bracket annexed to B11, wherein, the payment of interest on the amount due was directed to be exempted. So, you notice to the respondents of the petitioner taking necessary steps. Are you accepting? Accept notice on behalf of only R1? Only R1 accepts notice on behalf of R1. Issue notice to the remaining respondents of the petitioner taking steps. Copy of the paper book.
We have my.
You're on caveat?
I am on
okay. Then enters appearance on caveat. Who's on caveat enters appearance, count to be filed within. For other amount paid?
Yes,
besides interest, you receive.
Besides interest, if it meets my lady's pleasure, may I make one suggestion? These are class employees might have taken a voluntary retirement in subsequent years. The
clarifications could be so.
And don't forget, 3 days before the same very bench, very same 3 days before, has taken note by for you to say that you did not raise this objection before the bench. You don't know whatever you passed 3 days back. 20, 40, 50 cases.
You have pointed out
the your duty, your case you have pointed.
Why did you not point out?
You don't assist and you point out the fault of the court. You don't assist, it is your. What is happening in other court, the court is supposed to forget as it is. Otherwise, you will say we are coming with a prejudice mind. If we keep remembering all our orders in all case. We come with an open mind. No less on the council to point out that look here, refresh your memory kindly.
No, it's not the same bench. It was a coordinate bench. Same bench. Use the word coordinate. I'll use the word coordinate. Same bench. Then you should have.
That is your duty, counsel. That is why the courts are put to embarrassment because of this type of action by the bar.
Subsequent to filing of this agreement, one second, taking this order, review was filed by these persons, review was dismissed. This order has been confirmed.
That mechanism.
Yes, it was done.
It doesn't get better because they file a review. Why did you not point out to the court in 10 days before you have passed this or 15 days before you passed it?
It was pointed out.
Don't tell on that. Don't tell on.
Yes, it was pointed out.
Where you said it in the SLP?
It was
Let's see. That it was pointed out.
Don't come and make this stand. We don't appreciate that. We don't appreciate such type of
Then you should.
argument in the court.
That you pointed it out to the court that you had passed a similar order in an earlier case and you're varying your order here.
Don't even attempt to make that submission. Second time, counsel will impose cost on you personally.
I know.
The moment you open your mouth and impute any motive to the court, will put personal cost on the counsel. Let there be no doubt about it.
Particularly when the court.
And if you have the guts, put it on record. Then we'll see what we'll do.
Anyway.
Is under my custody. She is now 17 years old. The total victory amount is 29 lakhs.
Return amount, there was a settlement?
There was no settlement. There's a settlement with the father-in-law.
To the respondent or the commissioner taking every step still further orders operation of the clean judgment shall be instated. Condone the deal.
Published. Item 14.
Yes.
Including order my lord that Highcourt ignored the order, earlier order of my lord 5/10/2006 my lord, which was noted by the learned Trundle my lord, wherein my lord the statement was made my lord that he's not agreed my lord, just turn to my lord page 61 my lord.
No, counsel, after withdrawing the 7/10/2006 charge sheet, what is the net result?
My lord, in fact 17/10/2006 page 63, why that was withdrawn? Just
No. What is the result? What is the result after that?
That was withdrawn because my lord the statements were my lord on 5/10/2006 my lord that he's not agreed to the charge sheet below. Just come to my lord 17.
We are asking your proposition. Suppose you withdraw this, then what is the position? And
no, that was withdrawn with that my lord because my lord earlier to that my lord that
Why, sir, 1 minute, while reserving your right to issue a fresh charge sheet, was it withdrawn?
just my lord page 63 for him.
Let us see.
Page 63.
While reserving the right.
Yes, Lord. Page 63. That was the order 17/10/2000. In the light of the Honorable High Court, Madhya Pradesh Jabalpur order dated, it has been held that relevant authority has joined itself with the district authority for all purposes in this inquiry that has initiated against the petitioner Balwant Rai also. Just come to this order number 5/10/2006.
It will not turn to anything. Read the second part.
That in view of the upper order, that is.
Don't explain. Read it.
In view of the above order, the understanding is of the opinion that it should be the regular district authority to proceed with the said inquiry. If required right from the state of issuing the charge sheet, etc. Thus the charge sheet, that was the earlier action, thus the charge sheet dated 2/6/2006 issued by letter date so and so is withdrawn. That is in terms of the earlier order. That
after this, what did you do?
Well, after this, my lord, that he opposed the learned Trundle my lord. After that, he challenged this order my lord before the learned Trundle my lord. Just return to my lord that learned Trundle page 128.
Yes.
Page 128. And just my lord, page 28, my lord, I will read only one para my lord on page 131.
What is this?
My lord, that is my lord, he challenged my lord the various orders below. The original page 128.
Drop the entire proceeding.
Yes, my lord. And page 31, my lord, for a minute. Page 31, page 6. Para 6, my lord.
Page 131.
Para 6. During the pendency of the original application, so the applicant brought to the notice of the tribunal that regular disciplinary authority has appointed by the department on 10/5/2006 to initiate the disciplinary proceeding afresh from the stage of the charge sheet. However, no fresh charge sheet has been issued by the disciplinary authority. However, the applicant challenged the order dated 16/5/2005, whereby the petitioner case was forwarded to Dr. So and so for initiating the department proceedings from the stage from the issue of the charge sheet was rejected. And that the applicant filed the so and so against the order of this so and so, which was disposed of by order dated 5/10/2006. With the observation that clearly that as the regularly authority has joined he shall be the disciplinary authority for all purposes in respect of the inquiry.
No, counsel, we are just moving around in circles. You initially gave him a charge sheet in 1995. Subsequently, it came to be quashed, another charge sheet that also came to be quashed. Now you withdraw the second charge sheet of 2006, okay? With indicating that you are going to give him a new fresh charge sheet with the disciplinary authority. Okay, now let us stop. After that,
To that, my lord, he filed various orders, my lord, and the correct OA was dismissed. He made a statement that, my lord, just, my lord,
Whatever he did decide.
understand what
The
you
manage
do.
after 17-10-6, we are trying to.
17
Don't
and
use his stand is
my lord, 17
and
and
a crutch for you.
my lord, 17 and 2006, he filed another OA, my lord.
Again, what he did,
Then what he did?
counsel, don't use
Hold on.
litigation as a crutch for your conduct. You are an employer. You withdrew it saying a fresh charge sheet will be issued. What did you do? Don't talk about what he did.
The statement that he is not agreeing with the previous charge sheet, let my lord, the dismissal authority has been appointed by the secretary. That
This
is
is the point we wanted to hear from you. So you admit that you did not issue him a second charge sheet. You only appointed a another officer to conduct the inquiry.
my lord, I will read my lord page 62 for a minute.
Same inquiry.
My lord, page 62 for a minute, my lord.
We have read more than what you are trying to make us read, counsel.
Hold on, sorry, my lord.
We haven't come here just like that to have a casual talk with you.
Rest. You're
So
not.
according to you, 12/12/1995 charge sheet is revived, according to you.
Yes.
Is it possible when it has been specifically
Once
called?
he made the statement before.
Oh, okay. So his conduct and your conduct
What you will react to.
will revive that charge sheet.
He made the statement since the regular reflect.
So if you made a regular statement, then you should have reiterated that very nature of the charge sheet and give it to him. A cost thing will be revived just because the parties agree. Why don't you impose cost on you? This is the understanding you have.
So sorry, you can't use his responses as a crutch for your
And
conduct.
you by a party can agree and then make it infractuous and order of the
So
court.
sorry, you can't permit it. Delay of 317 days, condoned. Next.
Item 15.
Please, Your Lordship. Your Lordship, may kindly turn to page 9, Your Lordship, of the April judgment.
15 will be not before this bench. I'm sorry, I believe there are some orders that were passed by while in the High Court. Would not be proper for me to hear this. Go to another bench.
Please.
Item 16 and 73.
Please. So this will be tagged with the name item.
Yes, but why is it that each one is being filed all over the time? Why is it that you don't finish filing? You've already issued notice in 8 or 9.
No, these
The
orders.
bits and pieces, they're coming all over.
Yeah, I agree with you.
Why?
Because the impugn orders are coming relatedly. Also, they're all subsequent impugn orders. Because in this case, our impugn order is different. Very recent impugn order is for
Make sure all of them are filed and whatever is the pipeline is wrapped up.
Please.
16 and 75, 73 all combine same orders as in the earlier matters. Notice stay, condone the delay, tag with. Next.
Great.
Otherwise, if you come up repeatedly, then the other side will be prejudiced. You take a time out for 1 year, you keep filing, and 1 year they'll keep waiting.
And
Pick up a case and we'll decide that.
Side this, others will follow suit.
You can't let the other side be prejudiced. You are state and they are individuals.
yes, exactly.
Yes.
Item 17.
But it has two cases. One is the injured case where the medical bills of 50 lakh has been considered.
One is deceased, the other is injured. What is your grievance turn by turn?
Case. Lord, in the case of the deceased, Lord, or in the case of the not injured, Lord, there are 50 lakh bills, Lord, which have been brought on record. But your Lordship, the proof with respect to the payment has not been brought on record, Lord. Lord, that is my first grievance with respect to the injury case. Only on that portion.
Not the bills are for which institution?
Lord, the bills of pertains to the hospital fan, I show the page number 20.
Reputed hospital or just
Not the government hospital, Lord.
Then why should we, you think any hospital will, without,
they will let you go.
without receiving payment will do?
They don't even let the dead cost be
Payment
taken
proofs
away.
are not being filed on record, Lord, with respect to that. The payment proof with respect to the payment of bill has.
Counsel, this is a new argument I am hearing. A bill is produced with regard to payment and you say no issue, how you have paid? This has never been.
Next time,
I didn't think.
show us a receipt, you'll say, show us the bill.
Show us the bill, how you paid, how much cash, how much.
That will not be.
Yeah, sorry, that we will not.
Lord, sir, Lord, because the bills.
That
You have paid, you are the income tax.
Not the injured one. Not because the bills has the heading with respect
Now
to
come to the decision.
the. Lord, if your Lordship may come to the next issue, Lord, which is at page number 39,
Vishnu Kumar,
Lord. Yes, your Lordship, Lord, he stated that he is
page
the.
39.
The page 39, your Lordship. If my Lord may see para number 51, my Lord, the income proof
Yes,
is.
proceed. Just a minute, we're just turning the page.
Please.
Yes, 59. Just,
P1.
yes, please, 39.
Lord, para number 51.
Yes.
The Lordship, the tribunal has taken the income of rupees 20,000 per month. Though your Lordship, no authentic proof with respect to this has not been proved.
Clerk of an advocate.
Please, Your Lordship. Not only the salary record has been shown.
Which place? Which place?
Page,
No. Which was the place?
para number 51. Your Lordship.
Oh, no.
Accident happened. Where were they residing? Which court?
Location,
Please,
location.
Your Lord. Lord, this is Lord at sign, Lord, if I give the detail. Yes.
Where did the accident?
What is the place of the accident?
Sorry. Lord General.
And the date of the accident is 2016.
Please, sorry.
And he was clerk plus advocate.
Please.
Which advocate?
Lord, the advocate has also appeared as a witness at PW3, page number 25.
Suresh Kumar.
Please, Your Lordship. Lord, he has given only his own certificates, Lord, to not only please that the minimum wages must have been resorted to.
Don't we all know how a clerk is paid? We are all part of the legal fitters. How does the clerk?
Lord, the amount basically, Lord, that is 27 lakh,
You
Lord.
want us to be candid too. You
Lord,
know how clerks are paid,
please.
not entirely by the law.
They put 20,000 for a clerk.
Not some amount
That's
comes.
normally not by the lawyer.
That's-
Many times you know that the client directly pays
Please,
the
Your
clerk.
Lord, that is there.
That's why whatever the lawyer will be paying will be a cushion for the other payment that comes directly to a client.
Well, Lord, my respectful submission, Lord, the amount is around 37 lakh,
And
15,000.
there's a loss. This is a case where he has sustained multiple injuries. What is the extent of his injuries?
Do not see, this is the case of the deceased.
See, so sorry. This is the other gentleman.
Yes, Your Lord.
No, we will not like that. No problem.
Only these two.
Condone the delay. 46 days, condone the delay.
Item 18,
Yes.
Lord, in this case, Lord, like so, Lord, case,
You are the driver of the wedding.
yes,
Yes. What is your grievance?
grievances, Lord, that the order which has been passed, Lord, let's point out case 2, Lord, so that's case 5, Lord.
Yes.
That way it has come on record the
So
evidence.
recovery from you and the owner.
Yes, Lord. But Lord, the finding which has been considered at page number 24, Lord.
According to you, it was not required of it. A fitness certificate was not required. It was valid
It
for 1
is required, but it has not been issued by RTO, Lord. I had submitted my everything, payment has been.
You have taken a ground that there is no necessity for issuance of a new fitness certificate. Vehicle in question.
We have already applied and paid the amount, Lord.
Why did you apply? If you decided that it was not required, then why would you apply?
Lord, that's the process we have to apply, Lord.
Either you don't have to apply, you don't need it, and
No, Lord,
apply.
it's need, Lord. We had applied in January 2019, Lord. We had made the entire payment, Lord. Page 20.
Council, you make the payment for issuance of a certificate. Can that certificate not be refused? Suppose there is defect. So how can you presume that because you submitted your
Fitness
fee,
certificate application.
a positive certificate would be issued to you? Why
Lord,
not?
page 24.
How do you presume that?
24 for a moment, Lord. That's why I'm saying, Lord, it's exhibit DW9, Lord.
What is it?
It says that the
Your receipt, not the certificate.
Council,
Lord,
we
that
are.
was present for that. That was issued by the
Wait,
RTO, Lord.
that is-
Page 24. That was present before the RTO, Lord.
That is it.
Yes.
Yes, what is it at 24? Come to 24. Yes,
Application attached with the application submitted by the applicant mobile license server was presented in this office for registration as a taxi vehicle, Lord.
So,
we just started by asking you that was the certificate issued?
it's a fitness certificate, not with regard to whether it will be applied as a taxi or a private. It says that it is registration as a taxi.
Presented for registration.
As a taxi.
My lord,
That helped.
My lord,
Because your-
may I tell you also, I had paid that the insurance has been done, but at the
Now again you are skirting. We are asking a pointed question with regard to whether a fitness certificate with regard to a vehicle which carries passengers, taxi vehicle.
yes, Lord.
Do you have to have a fitness certificate so that
Yes,
the
Lord.
passengers are safe?
Yes,
You
Lord.
say you had applied,
We
they
had-
had not issued.
They had not, Lord.
So, are they
So why-
obliged to issue a purchase certificate?
Why-
Suppose they came up with 5 defects,
Why
then what
did you
happens?
apply it? Why did you apply it?
How can you apply without getting it?
Apply
It is not that you do your job and then it's a ministerial job. No. Then the inquiry starts. When the inquiry will start, they will come and look, your brake is okay, your this is okay or that. How do you presume just because you've submitted a fee? This is, I don't know how to make it.
That's the involvement, but that's matter.
Sorry, no.
But
You have to be careful when you take passengers
Why
also.
apply?
But
You are in a hurry.
passenger versus my son has been passed away, my lord. I was driving for.
Right, but that vehicle could not have applied unless the authority certified you that yes, it is in a condition to be
There
utilized.
were two, Adil and Umar. Who passed away?
Adil's son is passed away. That's the honor of the vehicle, my lord.
Adil and who's Umar?
My lord, Umar,
Farooq. Both succumbed to their injuries.
yes, my lord. They
Who's
have
the other person?
other person.
One is your son, other is not your son.
No, my lord. Other is not.
No,
Sorry. No merits.
Item 19. Great reason. Because in this case, the degree of divorce has been passed against the petitioner wife.
Yes.
The Honorable High Court as well as the High Court has not considered that it is only on the ground that she had filed a criminal case against the husband and was not able to prove it. Only on this very ground the divorce decree has been passed. There is no alimony awarded to the wife.
Did you ask for that?
My lords, no, I didn't ask. My lords, there is no application. There is a daughter, 9 years.
Notice, condone the deviation notice to the, on the petitioner taking necessary operation of the appeal judgment. No, this is dismissed in favor of RH, only notice, nothing else. List on. Service.
My lords may stay, otherwise he can get.
What do you say?
You see, the trouble here is that the decree was granted in 2019
And then I went
in its favor. Was there a stay during the entire?
before the Honorable High Court, there was a stay. I can find that on record.
The decree of divorce granted by the learned family court in favor of the respondent shall remain stay. Operation of the decree.
Highly obliged.
Next.
Item 20.
Yes, please.
My lord, the only legal question in this matter, my lord, is that the authority under the Senior Citizens Act, my lord, and the section 9 is.
What happened to you? Why did you not seek succession? You are challenging her. You say she's neither my mother nor my stepmother. She has no role to play in my father's life. What did you do in all this?
I vote with, my lord.
Why did you not have succession? Put up a will. If you were questioning it,
My lord, that's bill for the first time in 2018.
wherever it did, you did take.
How does it make a difference? When it was required, when you started interfering, then he came up with
no
doctor.
I protected the subject, if I may say. My lord, under section 9, there has to be maintenance law. Section 23, my lord, to declare certain property of section is null and void. My lord, how an enforcement of a will executed without the.
There is no enforcement. All that the tribunal has done it to say that there is a dispute, but that is subject matter of succession. This particular area can.
Look at the application, my lord. Only look at the application.
You been directed to hand over 7 rooms.
Man, on the basis of a will, my lord.
Maybe. You should have challenged it if you thought it was a fake will.
Let her be there. One room.
I could file always a super declaration to.
You are more entitled. You are more careful.
But that's the only point was that the bill was not for first time, so I think that was.
It was.
How can we are repeating?
I'm sorry.
We are repeating. The will would be any document you have. When do you use it? When you are under pressure and somebody is challenging something for you. You have in a position a document, you keep it with yourself. You produce the document only when the proceeding is made. When you are under challenge, what was the requirement? The world knew she was very sanguine about it. Old age, she is also old in age. No children, nothing from that marriage. So she was like, okay, I am protected. Now you start fingering her.
Sorry, no grounds.
But
21.
And she's getting pension also from your father.
Yes.
she is getting pension.
That was I'm saying. So all factors are the point of favor.
But Tarabai or Leelabai, my lord, that's the only issue.
Go to the proper forum. Tarabai.
I'm good.
Next.
21.
Your Lordship, both the Labour Court as well as the High Court has dismissed this case on limitation that I did not raise the dispute within 3 years. My only submission is yes, the termination is dated 31st December 2011. I filed only in March.
Demand notice in July 14, and that's when the after that you started the process.
Yes, Your Lordship, the demand notice is within time.
Maybe demand notice may be on time.
My submission is that the period during conciliation There's a period of 5 months which went in conciliation should have been excluded under Section 14 of the Limitation Act. Your Lordships have held that the Act applies also to the quasi-judicial bodies. I have quoted the judgment also.
You should not.
Highly obliged, Your Lordship.
Sections 14(1)(e) of the Act clearly stipulates when the premises is required for any family member, the family member should depend on the land. Plus, the eviction petition starts at page 36.
When did you enter the premises?
Um,
As a tenant?
as a tenant. Yes. Plus, I'm paying the occupation charges.
When did you enter the premises? Just ask.
Yes. 86 floors.
86.
Time for you to exit.
It was 36.
Sadar Bazaar, some pagadi, we
The
understand.
occupation charges, whatever.
To exit.
Lords, may I say?
The person who owns has to enjoy.
Plus, occupation charges has been by the client. Over on the higher side, I'm regularly.
It is his property. It is his property.
We are sorry, concurrent view of 2 courts, right? Long enough from 86 to 2026 would be another 2 years would take you to decades.
May I say this?
Now, what is the name?
38 years. 38 years is enough.
What we do is grant you some time. The date of the judgment,
Yes.
date was 1 to 2024, right?
Lords,
So what has the court given you any time?
no, Lords.
You want some time? We can
Lords,
consider.
we listen.
Besides that, we may not be able to give you anything.
Lords, the dependent, the word is very essential for that provision to
Sorry,
be.
we are not convinced on that, dependent or not otherwise. You
Yeah,
know,
no.
family looking at a place for business, sorry.
Go find another.
Now tell us, if you want time, it's okay, otherwise.
Yes,
we will-
Lords, he is 65-year-old.
So therefore, this is a commercial premises, we will look at 6 months, but you will add a line in your affidavit that you will not come back to this court, ask for time.
Lords, may
Because it's
I-
happening too often that we give time and all the parties, after exhausting the time, come back
Lords,
to us.
can it be 1 year, Lords?
No, not at all.
You're being generous enough, 6 months.
6 months
maybe
and it
6 months.
is, we are exceeding our own.
That's enough, because it's a commercial premises, you've been there for long, therefore 6 months you're entitled. Standard order, no merits, on an affidavit, continuing to pay use and occupation charges and handing over vacant leasehold possession to the landlord at the end of 6 months, reckoned from 1st of March, that's the only consideration. Will close in at end of September, that is on or before 30th September, disposed of, thanks.
All right.
Item 23,
Yes,
May please call. Look, subject matter arises below under the Employees Compensation Act. Read with the Abkari, Kerala Abkari Act.
yes, but you don't claim that he was illegally climbing on to that particular farm for
Only
the.
1 point, below. That's
Point.
1 point basis below. A toddy shop is allotted to a person. Trees are earmarked. It's against the point raised by us is that this tree was never marked, and he says that he's
Never marked, did you not stop him from climbing the tree, or was it doing
It's a toddy, below the excise.
Not doing it. The very fact that it was not earmarked and you were getting the man to do it first, you were also in collusion.
No. There were other,
Legally.
there were 15 trees were there, earmarked to be. That 15 trees were tapped and the toddy was being consumed from my shop. But not from this shop, that is a clear that he says that, the tapper says that he has got a license and is prepared to produce it. What he has done is, he has applied under the Right to Information Act, he got it. When he found that the tree was not licensed, he suppressed it. We have produced that before the Highcourt.
Even if it was suppressed, the injury is questionable. He suffered an injury, right?
But
He is undoubtedly owned by you. No doubt it is not